then also Minister in the Prime Minister's office during Tan Sri Muhyiddin Yassin's tenure, who will be speaking, I think, from the perspective of Persatu, the coalition, and some of their concerns if there is an anti-hopping mechanism. And with us also, yes, welcome YB. And with us also we have YB Larry Singh from Julau, MP for Julau. And YB Larry had a very interesting journey in this last few years. He contested the last general election as an independent in Julau and won. Then he joined Parti Keadilan Rakyat (PKR) as a member representing PKR. Then he left PKR to become an independent, and now YB Larry is the president of Parti Bangsa Malaysia, a new party, you know. So we certainly, you know, be very interested to hear your perspective on this issue of party hopping. So welcome YB Larry Singh. Yeah. So may I invite all the panelists to come and take your seat in front? Okay. All right. So maybe YB Gobind, you can sit here. YB Gobind, YB Redzuan, YB Larry. So the way we will be doing this is that we will give 7 to 8 minutes to each of the panelists here to speak from their experience, their perspective concerning this issue of anti-hopping law. What should it cover? You know, the obvious one is that anyone who leave their party would be covered, so there's no debate about that. But the more difficult question will be independents leaving or joining the party and then or leaving to become independent, and then the issue of coalition as a party leaving the coalition. What are the concerns and perspective from that, and also from YB Gobind, the challenges that the committee is facing and how are they tackling this and what are his views on all this, and also YB Azalina online, who will be sharing her journey and her conviction about how to deal with this issue. So first of all, I think I would like to invite YB Azalina, who is online, to speak to us for 7 to 8 minutes on her views on all this issue. YB Azalina, over to you.
Good morning, Thomas and all friends. Selamat Hari Raya, Maaf Zahir Batin. Thank you for giving me this opportunity with the Bar Council in Bersih. I've got some slides. I think I'll just go into it. First of all, I have to give a disclaimer that I'm not standing here or sitting here talking on behalf of the government or my party or even Barisan Nasional. So don't have to really overthink on what I have to say. All right, party hopping scenarios. I've got I'm putting it on two concepts, Thomas, between voluntary hopping and involuntary hopping. The voluntary hopping for me is whereby, as you know, the standard definition that everybody, I think, and even the public is aware, where the party MP hops from one party, migrates to another coalition, or independent MP stands for election, then join. And then lastly, for example, the party who leaves the party to become independent MP. Now that is voluntary, whereby you intentionally want to jump for whatever reason. The other block that I'm putting is the involuntary or MP that jump. It's like the frog that is forced to jump. So there is one where I emphasize on the meaning of expulsion. This is where I put in this box. Now, when I look at the next slide on consideration for grounds of expulsion, I think what you need to understand, there are 4 questions that I'm putting in, which is like, does an MP represent the party or the constituency? Secondly, do you consider the MP as a free agent in Parliament? And thirdly, do you consider the imperative of the parties to maintain discipline when an MP comes from a political party? And then lastly, the possibility of recall to have a solution on expulsion. Now, I want to talk more about expulsion than anything else. Well, because the PSSC hasn't reached expulsion yet, so I don't think so I'll be offending any PSSC discussion. But this is my personal view, because I believe with Gobind there and everybody there, you're quite aware that I think the government and the PSSC is quite clear on the hopping from the perspective of voluntary jumping. Right? Let's go to the first one, which is, does an MP represent the party or the constituency? Now, when I want to speak about this, I think you cannot deny the fact that you look into any dictionary, for example, the Concise Oxford Dictionary, there is, when you talk about MP representing the constituency and the MP representing the party in the constituency. Of course, the benefit of a party is the financial support, the candidate writes on the reputation of the party, the policies of the party, the development of the service center. That is for the party. On the constituency. You know, with the, for example, in my kawasan in Pengerang, out of 40,000, the next PRU 15, with the automatic voters and undi 18, I am looking into 54,000 voters, an increase of 14,000 as of this year. So for me alone, to move in a big area by being a party member, running under a party ticket, of course, it's much easier to canvass for a vote and also to give up services after I have run into that constituency and become a member of parliament there. Now, that is, of course, when the party is representing the party or the constituency, especially from the party perspective. Okay, next, I want to raise this element of, for example, to look into the, next slide, please, on the question of Article 43.2. Now, this article for me, as you know, this is an article which is, I think, I call it the basically the throne article, you know, whereby under Article 43.2A, it speaks clearly that the king shall appoint Prime Minister, a member of the House of Representatives, and his judgment is likely to command the confidence of the majority of the members of the House. For me, it looks quite clearly that it doesn't write any statement on the MP representing a political party. It looks like the MP under Article 43.2 to choose the leader of the House. I think if you look at 43.2, for most of the lawyers, you're quite aware that when the MP is representing themselves in Parliament, the choice for the party representation is not clearly stated and it's always an implied motion. Now, I look at the next slide and I'll raise on this 1774, where Edmund Burke mentioned the meaning of the MPs as leaders. It's a general acceptance that the representative of the MPs is to himself when he's in Parliament. And he represents his constituency. Not many literature is written that the MPs are representing their political parties. Now, the other one I want the audience to consider also, when you talk about the MPs opinion on the parliamentary privileges. The next slide. You know very well, which is quite clear under Article 63. The MPs is given immunity. I mean, not absolute immunity, but some immunity, especially when the MP is raising up issues on constituency. If the MP breaches, the MP is taken to rights and privileges, not
the party is taken to the rights of the So this can also support the fact that MP is independent. And then the other one I want to quote, another example would be in reference to like on Article 102, which talks about the powers to authorize expenditure. You know very well, during the COVID time, emergency period, and Pago was the Prime Minister. There was a special budget session. Now, to raise all these articles of the Constitution, I would like to end on this topic of MP and independent agent under Section 124 of the Code. You know, Section 124 is quite clear. When an MP is induced or compelled to exercise or refrain from exercising independent and the lawful purpose. So now this section is meant to say that, for example, if an MP refuses to take instruction from the political party to withdraw support under Article 43, can the MP be seen or can the MP make a police report that the political party is asking the MP to break Section 124? This is for the members of the audience, for the lawyers to consider under my title heading of independent, and when the MP is deemed to be independent in Parliament. Okay, the third point is the element of expulsion against party discipline. I think one of the biggest consideration for expulsion is definitely Section 18 of the Societies Act. Because if an MP's seat is taken away, you know very well the outcome is that the party, if the party is being led by a draconian leader, because of Section 18C, which is an ouster clause section, you know very well that it's difficult for the individual party member to take action on the party. But at the same time, if you don't have an ouster clause under 18C, then you have a situation like in my party, 3.5 million members. Can you imagine? A very small, significant ketua cawangan issue is being brought to court, for example, on something that is a simple offense or dissatisfaction. Now, that will go in huge cases with 3.5 million members, for example. So, you know, there is a balance between the need or no need for an ouster clause. But then, of course, if you talk about expulsion as a conduct to punish the member of parliament on issues wanting or not wanting to cross the floor on policies or ideologies. For example, when UMNO was close to PAS under the Muafakat Nasional, for example, PAS is a right party, UMNO is a center-right party. I have an opinion in reference to child marriages, assuming my party says to me, well, you know, you have to support our partnership and support child marriages, and I go against it. And then an action is taken on me and I get expelled from my seat. So the question here is that morally right? So these are questions that we need to ask when you talk about expulsion. And I would like also to compare with other studies in other countries. And you look at Singapore very well. Article 46 of the Singapore Constitution talks about expulsion as one of the hopping. But well, that's Singapore. We shall not go further. Those from Johor can understand very well. I think Thomas is also quite aware. But that's Singapore. But India itself started on expulsion, then they withdrew it. Now, I think my next slide, my conclusion, ladies and gentlemen, is of course, I believe if the voters are the key decision makers, whether in an expulsion, which is involuntary hopping, or in normal anti-hopping situation, I think Bersih is going to present a paper on recall. And I believe recall would be the best remedy. You know, one of the strategies in some countries is that you may have an anti-defection law to tie up together with the anti-hopping law. Now, that would be a whole another set of journey. But what you can see from this is the fact that there is a buffer system. That for me, a recall remedy is a buffer system. Because you're allowing the voters to have that final say, whether the MP, for whatever reason, especially on grounds of expulsion, should continue or not. Because if you give back the powers to the voters, that would be one scenario to really separate between the voluntary hopping under constitutional amendment and the involuntary act of expulsion under the Society Act. So then you can tie up with more of a protective or buffer system. Because you have to really be fair to the MPs, especially on issues crossing of the floor. And last but not least, I would like to end well, you know, I've done the private members bill. Of course, he got kicked out on grounds that it's too expensive, which I don't quite understand. Why is it when it comes to voters, everything's expensive? When it comes to other things, it's not expensive. So I hope the lawyers in the Bar Council will protect me whenever I get arrested for saying that. Just a Hari Raya joke. So anyway, I'll end it with my famous quote of Churchill. Please, Thomas, you may be bored with this quote. But again, the first duty of every MP is to do what he thinks is his faithful and disinterested judgment. His second duty is to his constituency, who he represents, but not the delegate. And then he quotes Burke again. It is not only the third place that his duty to his party organization or program takes rank, but then again, as you know how Churchill would say, he still qualifies his statements by saying that if you do observe, but then it depends on which order you're putting as in priority. So I think for a lot of political parties, as of now, I believe that they would want to see expulsion as also an act of hopping. But I think I would also believe that there should be more further in-depth discussion with all political parties to see from their perspective and also from the voters' perspective and the MP's perspective. So thank you very much to Bersih and Bar Council, and I'll take questions later.
Thank you, YB. Thank you, YB Azalina, for a very rich and really, I think, showing the different levels of consideration we have to take in coming out with a solution. Certainly, I think the ending quote by Churchill does put it very clearly, you know, the role of the MP in our country. Sometimes there are confusion about loyalty. Should I be loyal to the party who feel me to represent them, or should I be loyal to the voters who elected me, and ultimately the country? What is good for the country? I think that is an order that Churchill put very nicely: the country, the voters, the party. You know. So next, I would like to invite YB Larry to share. I think Gobind, you know, been in the committee, I think can sum up all these issues probably better. Then after that, I will have YB Redzuan to share from the perspective of a party leaving a coalition. So YB Larry, over to you.
Thank you so much, Thomas. I thought perhaps maybe Gobind and Awan will start first, because being the seniority, you know, in Parliament and also in former cabinet ministers. But thank you so much for inviting me today. I think it's a real honor to be able to be given this platform to actually express the views that I've already expressed in Parliament regarding the issues.
Not ready.
Oh, it's not clear. Mic set over more? Yeah. Hello, is it clear? That's enough? Hello, is it better? Okay, thank you. Yeah, thank you very much for inviting me today. I think this is a very good platform for us to discuss and to understand and to share our ideas on how we should move forward with the anti-hopping law. I know it's not going to be called as such. Perhaps it's another name, but in essence, this is what it is. Personally, from my experience, I think coming from the point of view as a elected representative, elected on an independent ticket, not so much in my capacity now as a president of the party, but based on what has transpired in 2018. I think what's very important to understand is how does an independent get elected in the first place? And what are the sort of issues, basis, considerations that the constituents take into account when doing so? Well, as you know, 2018 I was elected. I won by a majority of 55% of the total votes. My constituency is the land size of Melaka and Perlis together, but only with a population of 25,000 voters. Turnout was about 70%. But I would say that I won this platform not because of any other party-related issues. In fact, it was just a straight fight. But it was only on the issue of personalities, which is often the case when independents win the election. This is not just exclusive to Julau in 2018 in PRU 14. My uncle also stood for election in 2011 as an independent in the state seat of Plagus, which I formerly represented, and he won by 58% of the vote as an independent on the issue that I was sacked from the party which I represented, and therefore he, being the member of the family, stood up and he won. So I think that is also the case in Selangor, I would imagine, also in the case in Lubwantu in 2018. So generally speaking, independents are not binded by issues of party, issues of bigger issues of nation, but it's really local issues that affected the change of those who were formerly incumbents. And I believe that as an independent, because we are given this mandate at the point of election, people trust independents to make the best judgment, choice, and decisions for the constituencies, for the constituents. And therefore, if the decision for an independent is to move on from there to join a party of his or her choice, I believe that is something that the voters would have easily accepted. In fact, I don't believe there's any independent who won as an independent and remained as an independent to the end of the term. Of course, the issue of whether this is considered hopping, is it against the views and interests of the people? Definitely not. Because the fact is that people voted them to give him the trust to make the decision for them. Now, the independents did not rely on any funding from the party, as we saw on the slide earlier. They did not use any slogans or any narrative from any party, nor did they use any service centers. So everything is borne by the independent. So I think that is a very big distinction that we need to make here. And of course, if you look at the name anti-hopping law, or formerly, as many would coin it, anti-party hopping, there is no party in the case of independence. So I think that is something that we need to be very clear about. Now, what I do believe as a member of parliament is that I do believe that we do need to pass a law, as you mentioned in June, that's going to happen. I believe we need to pass a law. I believe that law, there's no perfect law that's going to be in place that everyone can accept. I've studied the matter. I personally believe that if we were to pass this, there will be ramifications, there will be consequences, and unintended ones as well. So I believe that, yes, it will be painful, but it needs to be done. Now, that is the point of my view. I think I've just been told that my time is up. So I hand over. No?
It's not the bell.
It's not the bell. Okay. It's not the bell. So personally, I just feel that yes, it's important. I don't believe it is right for a member of a party to become an independent after he won or he or she won under a party ticket. I think that's morally wrong. But I do believe that it is correct and also proper if a person won as independent and decide to move on afterwards, whether it's from one party or to the next. Because the point of time we have to look at is a point of time when they were elected, 2018. And that is the most important checkpoint. Okay, so that's my personal view. Thank you so much, Thomas.
Thank you, Larry, for sharing, I think, your perspective from your own experience in Julau. The question, I think, really, maybe later we can ask is whether Julau or in Sarawak is representative of the rest of the country on how voters in other places vote. Do they vote for the individual candidate or do they vote for the party? And even the question, do they vote for the coalition, regardless? So I think these are the kind of questions that we want to discuss afterwards. Next, I would like to give the time over to YB Datuk Seri Redzuan to share his perspective and also some of the concern that he may have if there is such an anti-hopping law or mechanism that come into place. So YB Redzuan.
Terima kasih Thomas. Selamat pagi, selamat hari raya kepada semua. But you hear my vocal cord not so good, but don't worry, I'm negative. I just tested this morning before I came here. Again, the NT or EHL has been much talked about. And I think Gobind know, I'm not sure whether the Jawatan Kuasa technical, but it's on the steering committee. And we've discussed this to greater details. One of the issue today, and I always be saying this, that for the member of parliament to support the constitutional amendments, that we must make clear what are the scope of the bills that we're going to table. In its raw form, we're going to have a lot of debates. What constitutes the constitutional amendment to allow the bill to be tabled and subsequently be passed? It hinges on two, which have been always put affirmatively to my own party, that party to party, it is classified as hopping. When it comes to coalition, something that can be debated. When it comes to independent to party, it's not going to be called as hopping. But party to independent could be hopping. These are a couple of issues that we thresh out even with the AGC when we're trying to draft the final bill before it gets presented on the 7th of June, hopefully. Now, for my case personally, there are two things here. Either you are a people's representative or you are party representative. And I was never a member of any party before I joined politics. Yeah? And I was asked to contest in Gajah. So I become a party representative. Then I didn't know then whether I could amass enough of votes to win the constituent. So it's how people perceive in terms of in terms of hopping. You are given the mandate by the party to garner support, or you are actually from the grassroots trying to be people's representative. Now, I think the recall that is proposed by Azalina could be more fitting because it can measure who you are, what you are as a status of a member of parliament. And I'm more inclined to look at the recall rather than, well, it can be combined rather than having a raw form of trying to punish hoppers or frogs, if you call it. Now, to be fair, for those that is hopping, as you see the collapse of Pakatan Harapan, if there was a law, they should seek re-election. And because they have betrayed the mandate of the people. On the other hand also, they have also go against the Watika. And I'm the president of the party, yeah? And I give you the certificate so-called to contest. And you move away or you break away from what I've mandated to you. And that is hopping. Yeah? But on the other hand, if you look at the Bersatu as part of Pakatan Harapan previously, then I might be looking at myself being a follower rather than a leader when it comes to party, because we follow party hierarchy. The consensus of the party is to move away from Pakatan Harapan. Now, how do you then define the position to Dr. Mahathir if there was a party hopping law? He was not with the consensus. He's expelled, he resigned, but he remains the MP of Langkawi. If we had a law, well, how do we deal with it? If we have a law, what happened to Langkawi, for example? And what happened if I don't follow consensus, a breakaway consensus, not to be with Bersatu living Pakatan Harapan then? Am I subject to expulsion? Then will I be considered or I will be governed by the anti-hopping law if there was such a law then? What happened to the future? But I think two clear things that I just said earlier. The party hopping must be penalized. Must be. Living coalition is something that is governed by various factors, including pre-electoral pact and so on. That's something you need to further dissect and see the definition of anti-party hopping law. It's going to be like not tomorrow, but I think it's going to be over time. The scope can be widened once we have the constitutional amendment approved in Parliament 2/3 majority. So the first two, I think more importantly, we have to exclude expulsion, because expulsion gives the full power to the president of the party to decide the fate of the MP. I'll give you a scenario, not being prejudiced about what's happening today. Say the president of a party decide to expel a member of parliament from borough for not towing party line, and you have instability. But he has a recourse. He can go to parliament, as Azalina said, under our constitution. Prime Minister is at the support of the MPs in parliament, not by party. So there's a lot of uncertainties that can create instability. So that's why the power of the expulsion must be excluded from the EHL. The two should be sufficient today to explain to all MPs in support for the constitutional amendment. Otherwise, you're going to get greater debates, and people will just will try to defer their opinion and probably will not vote in parliament. And there are also hints that I hear that CSA, if you are from Bersatu, if I'm from Bersatu, if I don't support, say, a supply bill, I might be seen crossing the floor. Or does that constitute as party hopping? Because as Azalina said just now, when you are a member of parliament, you are people's representative. You are not party representative, because you're elected by people. That's how I sit as a person who is, I must say, was naive in politics. I joined politics in 2015 when we started Bersatu, and I'm not a frog. Not yet, perhaps. But a frog comes into play when you have been given the mandate to contest. If you are after parliament is dissolved, you are independent. You can go anywhere as independent to become people's representative. So that's my view about what's happening today. But I think bottom line is we must find a solution how to improve if there's already stability, or create stability if there isn't stability, because we must focus to move the country into a greater heights. Otherwise, will be 5 years politicking and 5 years remain undeveloped. That's my view. Whether you are DAP, whether you are Bersatu, you are UMNO, whether you are PAS, we must strive to work for the people. That's how I see it. Thank you.
Thank you, YB Redzuan. Yeah, I think the issue of expulsion is a difficult one, because quite clearly, you know, if there is an anti-hopping law, and the president of UMNO decided to sack Borough, then it's automatic seat vacancy. And you have a situation where really the country will be thrown into this situation where the prime ministers can be sacked if it's automatic. So the difference between, and this is a discussion that we will take up in the next session, the difference between anti-hopping law, the traditional version, and the anti-hopping recall law is that anti-hopping law is legislated and is automatic seat vacancy. That's the difference. The Wells recall is really going back to the same voters who put you into office or in an elected position in the first place for an affirmation or a rejection of your decision to leave the party, or even if you're sacked by the party, things like that. So that is the big difference. But I think the issue of coalition hopping is really taking to another layer of perplexity, because like YB Redzuan say, he followed the party. He didn't leave his party left the coalition. Should he be punished for that? And what about those who chose to stay true to the coalition and they were either sacked by the party? Should they lose their seat, Langkawi and the rest? Or should they not be held accountable, for being loyal to the coalition? So these are the kind of nuances and issues that we want to look at afterwards in our discussion. Next, I am very pleased to have YB Gobind Singh here, who I think really is confronted with all these issues as they deliberate and try to come up with a solution. So maybe YB Gobind can just share with us his perspective on all these issues.
Thank you very much, Thomas, Karen. Thank you for allowing us to use this venue for an issue which I think is very important and which needs to be discussed. Two matters that I wish to touch on before I go into the meat of it. First, this question as to whether or not the Select Committee should seek public feedback before they make a decision. I'm of the view that the Select Committee should conduct consultation sessions, especially those who are interested in the topic should be allowed to put forward their views and of course to perhaps discuss them with members of the committee if time permits. And the second thing is of course our position in Harapan that this bill, be it a constitutional amendment or otherwise, must be tabled and enforced in the coming session of Parliament, and of course, in any case, before the next elections. So I think that's why we are going through this process. We are trying to get a law in place so that this problem does not recur again after we go to the polls the next time. Now, I would also like to open up by just saying this. There are many different views as to how it is we should approach the subject. And of course, I'm open to all suggestions. Had a chat with Chinwat just now, some very good pointers there as well. So of course, what I'm going to say now would just reflect my general thinking of what the position is and what we need to deal with when we discuss this topic. What are we looking at? There's this concern, as Thomas said at the very outset in his opening remarks, that people now question the value in their vote. There are many out there who say that when it comes to elections, we listen to what candidates say. There are candidates from political parties, they are members of political parties. There are candidates from those political parties who are also in a coalition. And they go on stage and they say to the public at large, give us your support. We represent the views of this party. We represent the views of this coalition. And of course, if we are given a mandate, then this is what we will do. So I think we come back to that basic position. That to me is the anchor point. And of course, premised on that assurance that the campaign voters then say, okay, baik, kita bagi sokongan kerana inilah calon daripada parti sekian-sekian dan sebagainya. After that, are you at all held to that position? Can you just, after being voted in based on the strength of that campaign to the public, can you then stand up and say, look, I am now deciding that I'm going to support the other side, which the public in that election rejected? I think it really comes back down to that. So here we have several scenarios. First, of course, is where you are a member of a political party. This distinguishes the position with independence, as is the case with Larry. So you're a member of a political party. So for example, I'm a member of the DAP. Then of course, DAP decides that we want to be a part of a coalition. But the coalition is not registered. So there's also a distinction between a coalition that is registered and a coalition that is not. Of course, if you campaign as a coalition, when you say that, look, in the event we win, then this is the group that will lead, and ultimately these are the pledges that we make to the people. Do you then win on the strength of the coalition or of the party? So again, that becomes a question that you have to decide. To me, I think it starts with you being a member of a political party. And if you look at perhaps Singapore and what they have done, it's a very simple position taken where they deal with political parties. If you're a member of a political party and you cease to be a member of that political party later, then of course automatically by operation of law you lose your seat. And of course there's an election. Then of course people say that, what do you mean by cease? What do you mean by, cease membership of a party? How does that happen? So these are questions that you have to look at. And of course, in that discussion, we find that there are so many different reflections that come across. What do you mean by that? You resign. If you resign, of course, you cease to be a member of the political party. Then technically, that would mean that your seat is vacated because you were elected on the strength of a campaign which was premised on being a member of that political party. The other is, of course, where you decide for whichever reason whatsoever that you would like to join another political party. And many political parties have a clause in their constitution that when you join another political party, then of course you're no longer a member of that political party to begin with. So that's how you then cease to become a member of that political party. If that be the case, then of course, technically what would happen is you would then lose your seat, because by operation of law, that provision kicks in, because technically you have ceased to be a member of that political party. Now, these are instances which are quite cut and dry, which means that it is easy for you to determine the occurrence of it. So if there's a letter of resignation, then of course, you have to look at that letter of resignation and you say that he's resigned, therefore he's no more a member of that political party, and technically he has ceased to be a member of the political party. Similarly, if you have now an application to join another political party and the other political party says that he's a member now, then because of the constitution of the previous political party which prohibits that and says that if that happens, then he no longer is a member of that previous political party, you then cease to be a member of that political. These are the instances which are the more clear-cut instances, right? But there are also scenarios where you are in a political party, but you make decisions which are against the political party. So which means that you say, fine, I'll remain in the political party, but I'll support the other side. What do you do with that? So this is where I think we need to think about clear-cut scenarios which would, of course, attract the operation of law, resulting in which you cease to be a member, losing your seat. And there's also a case where, this is where Azalina's suggestion that we need to have, we start thinking about recall. There may be instances in which you act in a particular way that requires a thought, a thinking process as to whether or not that amounts to you ceasing to be a member of your political party and therefore having technically hopped. So the question is, who decides, right? Do you want to go back to a committee to decide it? Or do you say, let's go back to the people who elected you and ask them to decide? Now, this is what has happened. This is what I did. Technically, does it amount to hopping? The problem is, of course, to do it all in one go, it involves a lot. So what I think needs to be looked at is perhaps doing it in two stages. One, dealing with the more obvious, and as I said, the cut and dry instances, which is clear-cut party hopping. And then, of course, looking towards law that deals with recall at a later stage. For example, expulsion and what have you not. Those are aspects which I think involve greater discussion. In addition to that, of course, you also have that other dimension which you must think about, which is whether or not you're going to have a law that applies across the board at the federal level and across the states as well, or whether or not the states are going to have power to legislate in respect of anti-hopping provisions in their constitutions itself. Now, as all of us know, there's a decision, a federal court decision in the case of Nordin Saleh, where a challenge was taken in respect of anti-hopping laws in Kelantan. And of course, the federal court, the court held at that point in time, Supreme Court, I think, that by virtue of Article 10 of the Federal Constitution, you cannot have laws that prohibit a person from deciding which association he wants to join, because it's freedom of association. But that particular decision is now under review. There's a challenge in Penang, and I think that challenge is finding its way to the federal court. I think leave was granted 2 or 3 weeks ago. So that's a separate matter. It may be the case that the federal court might hold now that states have the power, as it stands, to make their own laws in respect of party hopping. So that can happen as well. But while that is in progress, do we now, as lawmakers, go ahead and decide whether or not the federal position that we are going to now propose also applies to the states? In other words, whilst you decide, let the courts decide on what the legal position is as it stands, do we legislate nevertheless and take a position? So that's also another area that I think everyone has to look at. So it really comes back down to different scenarios. I go back to membership of parties. As I outlined earlier, when you look at a political party and a member doing certain things which results in him ceasing to be a member, then of course he loses his seat. Then the question is coalition. If you are part of a coalition, and I think that's important, some may say, look, if the whole party leaves and we go and join someone else, it's not hopping. I think you come back to the basic anchor question, isn't it? If you go out to the public and you say to them, look, I am a member of this political party, my party is part of this coalition, and we are asking you to give us your support. You're supporting the party and the coalition. The question is, are you not now held to that? Can you go on later on to say, okay, fine, we as a whole party are moving out, so it's not hopping. But is it not the case that you went to the public and said to them earlier that you were part of this coalition, and that in the event you were given the mandate, you would govern together as that coalition? You come back to this basic question. So to what extent are we going to legislate? I think this is what we need to discuss. Do we stop at party membership, or do we look at also membership, party membership, but also in the context of the coalition in which you stand in the elections, be it a registered or unregistered coalition at that time? Then, of course, the next question that comes in is the use of a logo. Assuming for a moment you have a coalition, but you decide to use one party's logo, does that mean that you shift membership of your party because you're using a different logo? So I think these are all questions which must be dealt with. And when we look at amendments or new bills, laws that deal with this, we have to be very careful. We have been pushing. In Harapan, we have been saying that it must be done. We said that it must be done in the first session of Parliament. But then there was this issue as to whether or not it should be a constitutional amendment or it should be done by way of a bill which deals with this. Now, this is the reason why in the last session of Parliament, you find that there was tabled a proposed amendment to Article 10, which would get around the problem that you have with Nordin Saleh. So it deals with Article 10. In other words, what it proposes to do is to deal with that problem, the prohibition, so-called prohibition, because freedom of association would mean that you can't legislate. Any bill that is tabled and passed by Parliament, which deals with anti-hopping, would technically be unconstitutional by reason or by the reasoning in Nordin Saleh, because of the prohibition in Article 10. So the thinking there was move an amendment to Article 10, and then that article would allow, that amendment would allow Parliament to legislate in respect, in other words, separate bills for the purpose of anti-hopping. Now, there were objections to that. Let us be very clear about one thing. I think we must be very careful when it comes to dealing with the federal constitution, especially dealing with provisions which guarantee you certain rights. So you're talking about Article 10. Article 10 talks about certain freedoms, freedom of speech, association, what have you not. So we have to be careful when we look at how it is we're going to restrict those freedoms by way of amendment. So this is the reason why I think many of us in this room, came back with concerns and said, look, the amendment that is suggested is too wide. You're not just going, this amendment doesn't just allow anti-hopping law, it allows technically administrative interference as well with political parties later, and that can be done by legislation. not legislation which does not require two-thirds majority, just simple majority. So do you want to go down that path? This is why the matter was then referred to a select committee. Now, I'm more inclined to look at a constitutional amendment. I think that at the end of the day, this is something that is very, very important. And the law or the change that we bring about should be one which is carved into the constitution itself. Now, you don't have to deal necessarily with Article 10, right? Of course, there's a separate legal opinion that I have been given that says that Article 10 must also be refined. But I think there can be a separate part in the constitution which deals with anti-hopping. So that is one of the options that have been suggested by people who have come to see me. And I think that's something that should be put forward to the committee. And of course, the other suggestion is, of course, by way of bills. And of course, you go back to the Article 10 amendment again. I think that there are many different dimensions to this problem that we want to deal with in bringing about this new law. I'm not sure if we are going to be able to deal with every single part of that problem in the first attempt in the amendments to the Constitution or the bill that will be tabled. But I think we need to start somewhere. And I think when you need to start somewhere, you need to look at what it is, the problem that you need to deal with when you define an amendment or a new bill that you want to table in Parliament. As I said earlier, it really comes back down to this. There is an election, people get together, they go out to listen to candidates who ask them for support. These candidates say, we are part of a political party. We are part of this coalition. If we win, this is what we will do for you. People relying on those assurances, those representations, they make a decision. I think that must mean something. And I think the value that is attached to that vote must also hold for something. We must be able to say to the people that your vote matters. There is value in it. It counts. And you have a right to know that if you have made that decision, then the person to whom you have given that vote has certain liabilities and responsibilities to you as well as a voter. It cannot be the case that candidates come before people during elections, say to them ask them for support, and when they get the support, almost immediately sometimes do the exact opposite. I think that's a major problem. And if that is allowed to be, we are going to see uncertainty in our governments in years to come. I mean, I don't think there's going to be a resolution to it. Yeah. So this is why the process has taken some time. In Harapan, our position is that it must be done. It must be done. Perhaps we wanted it to be done by the end of May, but we hear now that there's a suggestion that it be done the first week of June. But in any case, we're pushing for it to be done before the next session of Parliament in a special sitting, and of course, it must be enforced before the next elections. I think here I come back to what I said earlier, that there will be views expressed by many of you here, and many of you here have approached me. I think that the consultation is very important. This is something that is going to impact on who we elect, the governments that we choose that are going to govern our country and build the future of our country. It's something that is so fundamental that I think that time given to people to give us the feedback, consultation is very important. But nevertheless, I think that we need to be strict and firm, moving ahead with timelines so that we actually get things done and we can actually see this law put into place, as I said, perhaps in a special sitting before the next session of Parliament. So I think that perhaps puts everything in a nutshell, and maybe I'll leave it at that and take some questions, Thomas. Thank you very much.
Thank you, YB. Thank you. I think the whole process of lawmaking, was highlighted in this journey towards making the constitutional amendment. I think this concern came about with the amendment to Article 10, really came about in some way because of a leak of the proposed amendment to the public. And I think when the lawyers, many of you are in this room, saw that together with us, we were alarmed at the wording of this amendment to Article 10. And only because of that, the ruckus raised and all this thing, that then people start to take a closer look, and then therefore led to now the deferment, the formation of the PSSC, which we welcome, because this is actually what it should have been from the very start. You know, a committee that is dedicated to look at this amendment to come up with this bill. But the whole question is that because of the lack of openness and transparency, you know, the public and many of the experts are here, were not able to give feedbacks. So, but nonetheless, you know, we are now, I would say, back on the track where there is a committee and there is also a consultation process in place, where I think many of these stakeholders, including us in Bresse, were asked to submit written submission to the committee. In fact, today is the deadline, just a reminder to all of you. Today is the deadline to submit to the PSSC. But still, I think it should point towards the process. I think any law that comes to the public and affects the public should be done in consultation and as transparent as possible, so that you can get the best mind, best view, and most inclusive views to be included in whatever new laws that come across. But we are hopeful that I think with now the different voices speaking up, we will have a good solution. But I think the other thing that YB Gobind, you also say that is that right now, because of time, you know, we should look at securing something, some of the more obvious one, like switching party, and maybe leaving question of expulsion or coalition to another time. But my expulsion, just expulsion. But my question to you, YB, is that would we have another opportunity like this? This is a unique opportunity. We have a bipartisan and support for these amendments, and it's a constitutional amendment. Would we have another opportunity if we miss this one? What are your thoughts?
Thank you, Thomas. Now, the position that we take is that you have two different areas that you need to look at. One is anti-hopping in itself. The other, of course, is recall. Recall, of course, will deal with those areas, as I said, where a bit more thinking has to go into the question of whether or not what has happened amounts to hopping. And if we can get it done in one go, of course, that would be the best scenario. And of course, I think that would deal with the problem more holistically. But of course, we all know that the recall law is something that is a lot more detailed than looking at provisions that deal with anti-hopping in itself. So the question is, how long will that take? And of course, if that takes time, and I think that also would require its whole process of consultation and what have you not, then of course, is that frame or that time frame going to be one that extends beyond this what you call parliamentary session that we are going to have? It may be the case. So this is where I think I see your concern. I totally agree with you. It is something that we need to deal with. Of course, the other way around it, something that Chin Huat was saying earlier, would be to find a mechanism by which the provisions which deal with hopping are dealt with now, because it's a constitutional amendment. But of course, there's a flexibility afforded for subsidiary legislation to come in, which deals with recall. That's one suggestion that has been put forward. Of course, the best way around it, I would think, is to put it all together so that it is, one constitutional amendment. But really now it's a question of whether or not we would be in time to do it all together.
Okay, so the concern that you have or rather, I think you acknowledge that all the other issues are less straightforward. Expulsion, coalition, leaving coalition, and different things can be addressed by recall. But the concern with recall is that it is a lot more complex. It may take more time to come out with a proper solution, a law, and you don't really have the time because the MOU has a time frame.
No, it's not about the MOU. It's about, let me just clarify, let me just put this clearly. In terms of party hopping and coalition hopping, I think we can deal with it now. That's okay, itu tak ada masalah. But it's just a question of recall. Recall involves procedure. How are you going to do it? The mechanisms of it. Right. Looking at other laws that need to be amended, Societies Act, what have you not. So it's a huge area in itself. Right. So to me, if we are going to put all of it together, there is a good chance that it will take a lot longer than we think, and that might be problematic. So at this point in time, all of it is being considered. The consultation is going on. The committee is taking views from everyone. We will still have to sit back. I'm not sure how many of you are going to come back with proposals, but proposals that have come to me personally, which talk about recall and all that, I can see that it is very detailed. In terms of party hopping, dealing with coalitions, that we can deal with now. To what extent we are going to go into the questions of recall, and of course, as I said, expulsion would explain in one way why it is recall may be important, because not all instances would be instances which would require or which would result or justify the what do you call a member of parliament or state assemblyman losing his seat. Yeah. So of course we need to go into all that. Then of course we have all the concerns raised by Datuk Azalina as well earlier. There are certain legal provisions that you got to look at. It comes to recall. You got the penal code. You've got Article 43. You've got Article 48(6). Article 48(6) is that provision which deals with, there was a provision that was brought forward into Constitution which prohibits a member of parliament who resigns from standing for elections again. Now you can't have that as well, because the whole idea is to go back to the people to get their mandate. So that can be dealt with now as well, because that's quite simple and straightforward. But as I said earlier, I think it's a process. We must start somewhere. We're trying to get everything done. But again, it depends on the detail that the recall procedure would require and the time that would take. So we may put forward what you call an amendment in different stages. But at this point in time, it's all still in discussion. And we welcome all your views in respect of what your thoughts are in this regard.
Okay. I do want to bring YB Azalina in. We have not forgotten her, especially on this issue of recall. But before we move to Larry, I know Larry also is waiting to jump in. But YB Azalina, can you respond to YB Gobind's concern about the recall election?
Thank you, Thomas. I think one of the problems that you face with recall is that we assume, when it comes to recall, we assume that the standard procedure of SPR would be coming in place. Because you can't do a recall. I think what YB Gobind is trying to say is that there is a lot of other extended laws that goes together. It's not so straightforward. But my emphasization, that could be the mechanics. But the messaging that we must give to the people before PRU 15 is that the country and the MPs are ready to allow the voters to have a bigger say. And I think the voters want that before they go out and vote. And that's what I said when my private member's bill was rejected by government on 2 occasions due to costing, because they say that, oh, you can't incurring costs because it'd be too expensive for SPR. I think that is a bit shortchanged lah, because you're not considering platforms for discussion. I mean, of course, Thomas, you raised very well that the PSSC is a fantastic platform. But our timeline is that the MOU ends in July. And I think a lot of us in the PSSC wants to see some amendment to the Constitution. Maybe, as what YB Gobind is saying, that maybe a new article in reference to only straightforward of anti-hopping. And then you can address and break away the element of expulsion in a second stage of discussion. I mean, that maybe we can consider. But again, you cannot deny that the laws that we have in reference to Society Act is a bit, is also draconian. I mean, my debate is pushing out the Sharia Samad clause, 48.6. I think YB Gobind is quite aware. Because as far as if you amend on Article 10 without touching 48, then you're just like lopsided on one ground. So you do it together. Then the next question is that you separate between voluntary and involuntary of hopping. So that's basically, I think, what YB Gobind is trying to say. The only thing that I can look at regardless is the timeline and the scheduling. Because rightly or wrongly so, to handle straightforward hopping, I think everybody is aware the amendment may be straightforward. But expulsion, you have to look at it differently. I have to concur with YB Gobind. But my concern is that if the government or the majority of the MPs agree for a fundamental change, then we have to look at other things. For example, CDF, Constituency Development Fund. We know very well these are the reasons why MPs jump. Because when they're on their own, they can't service the constituency, for example. Let's talk about fixed term. So nobody has to be nervous that the government can be dropped under 43, Article 43. So I think if the government wants to look or the MPs want to consider in-depth discussion, then you may have to package expulsion with a very thorough amendment to the constitution when it comes to voters' rights. I mean, that one we have to see. But for straight anti-hopping, I think the PSSC under the purview of the Minister of Law and all the ministers from the other side and the MPs from both sides, I think we're doing quite well on the discussion. The only thing is what you said, we need more experts to come in and guide us what is right and wrong. Sometimes, politicians, we may be going off tangent in our views. Thank you so much, Thomas.
Thank you, YB. Okay, YB Larry, you got something?
Yeah, I'd like to say that so far from all our panel, everyone has mentioned about recall. I just want to state my opinion that I am actually totally against recall. And the reason why I'm against recall is because in the context of East Malaysia, in the context of Sarawak in particular, I know my people well enough to say that
Tingkatan terbaru terhadap eksekutif entiti Gazprom Bank dan beberapa entiti perniagaan lain. Langkah ini sebagai cubaan terbaru Blok Barat untuk memberi tekanan terhadap Presiden Rusia Vladimir Putin susulan pencerobohan ke atas Ukraine. Menurut Presiden Joe Biden, negara anggota G7 akan menghentikan kebergantungan terhadap import minyak Rusia secara berperingkat. Amerika dan Eropah sebelum ini mengenakan sekatan ke atas Rusia. Ia disasarkan ke atas institusi kewangan utama entiti perniagaan dan individu yang mempunyai kaitan dengan tindakan Rusia menceroboh Ukraine. Presiden Ukraine Volodymyr Zelensky menyeru sokongan berterusan untuk menghadapi pencerobohan Rusia. Katanya Ukraine memerlukan 5 hingga 7 bilion dolar sokongan bulanan ketika perang berterusan dan kira-kira 600 bilion bantuan pembinaan semula sebaik saja perang berakhir.
Поки війна триває, ми потребуємо щомісячної підтримки на рівні від 5 до 7 мільярдів доларів. Коли війна завершиться, потрібно буде відновлювати зруйноване Росією на більше ніж 600 мільярдів доларів США. Це дуже багато для нашої держави. Це неможливо для України, але посильно для вас. І це не просто витрати для вас. Фінансова допомога Україні, допомога з післявоєнною відбудовою – це недопущення значно більших втрат вільного світу у майбутньому. Росія хоче піти далі в Європу, і всі потенційні агресори світу, які також хочуть зруйнувати життя сусідів, дивляться саме зараз, чи вдасться Росії та чи зможуть вони повторити.
Beliau berkata demikian ketika berucap kepada pemimpin kumpulan G7 menerusi sidang maya pada Ahad. Turut hadir ialah Perdana Menteri Kanada Justin Trudeau yang berada di Kiev untuk lawatan mengejut. Zelensky turut mengemukakan pakej sekatan yang baru dibangunkan untuk mengukuhkan larangan ke atas import dan ekspor Rusia. Shanghai mengetatkan penutupan COVID-19 dalam usaha baru untuk menghapuskan jangkitan di luar kawasan kuarantin menjelang akhir bulan ini. Sekatan di seluruh 16 daerah di bandar itu berkemungkinan akan berbeza-beza kerana beberapa daerah telah mencapai sasaran. Sekatan pergerakan secara amnya akan kekal sehingga akhir Mei. Ini berikutan kebimbangan lonjakan kes walaupun penurunan jumlah kes dalam wabak coronavirus terburuk di negara itu. Pendedahan menerusi akaun media sosial penduduk di beberapa daerah serta siaran media sosial menunjukkan kerajaan bandar itu mempercepat dan memperluaskan usaha untuk memindahkan kontak rapat kes positif ke pusat kuarantin pusat. Beberapa penduduk mendakwa mereka diarah berpindah ke kemudahan itu walaupun dengan
independence, so to speak. Today, as you see, if you want to put critical views about your own government as backbenchers, you might be reprimanded as being not towing the line. So you might be gradually compromise the position being a party member. If there is such thing as expulsion, if such thing as arising from, say, crossing the floor as deduced from not with the party in terms of supporting any bill, that can be not so good for the MPs because they will hold back putting their views as people representative. And I'm a backbencher, for example. I can put my critical views, but I can be ticked off for being like resonating opposition view. Yeah. So when you are the Dewan, you should be an MP, people representative rather than party representative. When it comes to certain critical issues, with regard to party matters, yes, you may take your stance. That's my view.
So, Redzuan, if there is a proposal, because I think the sticking point here is on the issue of expulsion. So, if you, okay, let's say we don't include expulsion as a definition of party hopping, and let's say what happened in Sheraton Move were to take place, and you exclude expulsion. The group led by Gomba in PKR, the 11 of them, knowing that there is this pathway where they can keep their seat, if they are sacked by the party, they choose not to resign from or leave the party.
No, the very reason why you have the bill, once you hop a party, now before you don't have the bill, you don't have the law. Once you hop, like the case of Gomba, seats vacated.
Yeah. So, but now if we say we exclude expulsion, let's say there's a bill now, we exclude expulsion. You leave a party, automatic lah, you lose your seat. But now we have this option, this new pathway. And if Sheraton move were to repeat itself after G15, and everybody know, okay, I can keep my seat if I'm sacked. But they, in effect, have already voted with the other side. They have already done everything to be with the other side. What then does it leave the party? Do they sack them or not to sack them?
I think
to sack means they keep their seat.
I think immaterial. Just don't put gombak. Say Alor Gajah. If there was an EHL, anti-party hopping law, right? I moved to DAP. I vacate the seat. That's the law, govern. Because I move from party to party. It doesn't take me to be sacked. Right? So that's my view. I mean, the moment you move a party, you vacate your seat. Then you can go for re-election or you resign.
But what if you don't want to, you want to keep your seat without going through a by-election?
Oh, no, this is so, where the law has got to come into place.
But you vote with DAP. You vote with DAP and your party, basically they want to sack you, but they can't sack you. Because if they sack you, you keep your seat. You want to keep your seat. So that is...
I didn't see your point, Thomas. It's just that if my party sack me, right?
All right.
My party sack me, that's what it's saying. I'm no longer a Bersatu member. I mean, I get to keep my seat. If there was any law, there wasn't any law. That's my point.
Yeah.
If there was a law, I'm vacating my seat.
Okay. What if the solution is that the committee comes out with an exception? It excludes expulsion. So if you expel, you don't lose your seat. Exclude expulsion. But except for, say, two situations, when it comes to confidence and supply bill, you vote against your party, then your sacking will lead to vacation of seat. In other words, you only these two other bills, everything you are free. Vote in your own conscience for as a people's representative. But except when it comes to confidence motion and supply bill, if you vote against the directive of the party and they sack you, would you support that?
If I'm against the party, say, the government today, Keluarga Malaysia, is tabling a bill in October. I'm not with the government, so to speak. And am I subjected to be sacked from the party? Is that your question? I think it shouldn't be.
It shouldn't be.
It shouldn't be.
Yeah.
Because it gives you the, although it may appear to be not with the government, give you the critical view about what's the bill all about. So MPs, I say, got to remain independent in Parliament to state their views for the betterment of the country as people representative. So I put my views, I mean, all the bills are subject to be debated anyway, and then you're going to voting in Parliament. So you can express your view, but when you put your critical views, does not mean that you're not, there's no secret ballot anyway. So does not mean that you're not or you're with the government. But my position, if you put your critical view to certain bills, if you are backbenchers, for example, people might seem to think that you are not with the party or with the coalition. This is, to me, is not good as far as trying to bring about progress through the legislative.
So you would not agree with that sort of
no, I will not.
Condition.
Yeah.
What about you, YB Azalina? If there is such an exception to expulsion that, you know, whereby it comes to confidence and supply, the party has a right to sack and vacate the seat. Would you support that?
Well, depends also because, you know, I always being a party member. I mean, Larry is from Sarawak to explain his party, the challenge. Like for me, my party historically has been so long. And as I say, I always say before I answer your question is that before you win, you offer yourself. After you win, you're servicing the rakyat. So to move on your own is very difficult. And then
when the party punishes you for not towing the line, and then you want an exemption, and your exemption you say comes from certain conduct, there's an exemption, then it's very difficult because then how is the MP going to do the job? Because in the end, this party still controls. When I spoke about recall, I think, Thomas, you must remember one thing that I'm trying to say. Indirectly, the recall procedure, no matter in what manner and what is the timeline or the referendum amount, we're giving it back to the people to decide. It's not about the people deciding whether you stay or you don't stay. It's the other way around. Before you are being expelled, or when the party wants to expel, the party has to think, well, maybe the Rakyat may not want him or her to go. And I think it's very good for the MP who has been servicing the Rakyat. Because then the MP can stand proud by saying that, look, regardless of which political party, my Rakyat still wants me there. Whoever you put against to fight with me may have a problem because my Rakyat wants me there. Then you can save a lot of money. But if you allow a political party, my biggest problem with a political party, I'm a Supreme Council member, but my biggest problem in a political party is that when the party makes a decision and then not every member has a say, like a big party like mine, this is where the conflict comes in. I quoted the example between PAS being right, my party is center-right. There are certain policies I don't agree, but I don't get my party leaders telling me to agree on certain things. But if my party leader is forcing me to agree on something that they have agreed without discussing with me, I think I'm going to have a lot of problem with my party because I won't agree. But my Rakyat and my voters in Pengerang, if I explain to them, if my party wants to expel me, and I explain to them why, A, B, C, D, my Rakyat may say, okay, I think we want you to stay. So basically what I'm trying to do now is that it doesn't matter because I think what Larry is trying to say is the difficulty or the abuse that can happen. But I think the concept of the recall, Thomas, can be very differently according to how we want it. It could be on timeline, it could be on numbers, it could be on percentage, not necessarily there's a standard form. But if you don't have that, maybe we have to tie up with something like an anti-defection law. So you can balance a buffer system so that if the MP is being punished for not towing the line, there must be a buffering system. That's all I ask for. So that it's fair for the MP from the party. If not, Thomas, a lot of us with this law may want to run as independent and then look at post-election coalition agreement. Because then we are more free to move and not join you, but sign another MOU to say, let's work together and I'll give you the vote. Maybe there's another option for the future if the party is still trying to control tight on how the members as MPs are moving on the ground. That's my personal view, not my party view. Thank you.
Thank you, YB. Thank you. Okay, I think that kind of like brings us very nicely to the close of this first session, which also I think prepares us for the next session that looks more at the difference between the anti-hopping law and the anti-hopping recall law, the details of these two things. So with that, I really want to thank you. Last words. Last words, YB Gobind.
Thank you very much, Thomas. I think all of us in this discussion today can understand the challenges ahead. Number one, we want to make sure that we show that we've reached that level where we can table and pass anti-hopping laws in Parliament. But at the same time, we are confronted with two scenarios. One where it's quite easy, as I said, the clear-cut situations, cut and dry situations, where you can see that a person has ceased to be a member of a party or ceased to be a member of a coalition. Right? Those are the broader and the more straightforward positions that we have. And I think those instances can be dealt with by way of constitutional amendments or even by way of a bill, which can be done, in the near future. What Azalina is saying I think just underscores what I said earlier, which is you're going to have instances in which an MP will say that he has a right to be heard before a decision is taken on him. So it's not the case that when he makes a decision, automatically he loses his seat. Now that is where we have this huge question as to what is the procedure. Are we going to just say that, okay, if we list out, like you were suggesting to YB Redzuan, you list out, for example, you don't support the supply bill, you don't support motions of confidence and what have you not. But the question is, where does it end? And of course, who is to determine those actual instances in which a member could have been said or can be said to have hopped? So that's why I think the whole question of talking about also a system that provides a buffer, which YB Azalina said needs to be put in place. That's also important because the MP needs to also be given that right to be heard in respect of a decision that he takes before his seat is vacated. In a case in which he argues that he has not ceased to be a member of his party or coalition, but he did something for a reason, that's when, of course, he goes back and the people decide. So it's for them to decide. But that will take time. Right, and the reason why I'm saying this in concluding is that I think this is also something that all of you here need to think about and perhaps come back to us with suggestions on. But it's all in the process. I think that the first part of it is sufficiently clear. We're dealing with it. The second part is still in discussion, and then of course the question is the timeline required, and maybe the need for us to move ahead with the first part first, and then of course. Think about whether or not the constitution or there will be amendments which allow for subsequent subsidiary legislation to deal with these problems later on. Thomas, there's a question from the floor. I'm not sure.
Yeah, Professor Wong.
Thanks. Sorry, but
go ahead.
You go ahead.
Okay. Go ahead.
Well, my question is very short. We have been talking about recall, but most people claim that it's very complicated. Indeed, you have 4 models at least in the world. And the one proposed by YB Azalina and Versailles is a fusion of the British and the British Columbian model. Question here is that we never really have a chance to debate about this. So Azalina's bill got blocked on the ground that this would cost a lot of money. And YB Redzuan, despite having a strong idea about recall, didn't get a chance to actually know what's the difference. So my question to you is that would the Parliamentary Committee and also the MOU Committee to take a position that even, let's say, we sort out the mechanism for the clear-cut cases of party hopping, would the committee, which has the power to extend its lifespan, to embark on looking into a YB Azalina bill? Because that allows us to start somewhere. Otherwise, next generation come, we will still say, recall is too complicated. Thank you.
May I answer that?
Yeah.
Thank you, Chinwat. I think this is what I said in my concluding remarks, that this is where we are now. There exist those clear instances which we can deal with, but we also recognize the fact that there may be a need for us to think about those instances which are not that clear and how we deal with it. Proposals are most welcome. Please put it forward. And of course, it's for the chairman to discuss it with you and subsequently to put it forward to the select committee. So as I said, please put forward your views on the matter.
Thank you. For conclusion, I just asked the question, would yourself personally, YB Redzuan, support the enactment of anti-hopping bill in whatever form it may take?
Yes, I'd like to go back to where you say about voters coming back. I think we must push this bill, get it approved, to have a change, so to speak. Now, to go beyond what I have said, focusing on enabling the bills through CA of Article 10 and 48. Yeah, we open up a lot of many other bills that we can think about, even recall. Yeah, so let this push through with your recommendation to get it passed and to get the optics to the younger voters so that they can come back and reinstitute, if you want to call, reinstall the right democracy in this country, so to speak.
Okay, thank you.
So I will support this bill, but I will defer for now as far as expulsion to be included in the anti-hopping law. Right. So there are two, as I say again, party to party, obvious, and of course, party to independence.
So expulsion.
Expulsion should be excluded. We can, as I said, once you amend the constitution, you can debate it further into another set of bills in the future if you want to refine in terms of protecting people's rights when it comes to voting in the constituency. All right, thank you.
Thank you. YB?
Thank you, Thomas. I think a lot have been said. And for me personally, I do support the law, anti-hopping law in any shape and form. Not because I think it will be a perfect, as I mentioned earlier, but I think this is we need to have a sort of basis, sort of parameters, basic parameters to avoid what has happened over the last few years that may destabilize the country's politics. But having said that, when I was listening to what all our panel speakers were saying, I was also reflecting upon other democracies, which developed democracies in Europe, whereby they have many changes of government within a fixed term, and sometimes I do feel that we shouldn't actually confine ourselves so strongly, so tight to a particular law. I think sometimes, yes, we will make mistakes along the way. The voters will punish us, and parties will learn to adapt and to know what to do and what not to do in such circumstances. I think we need to have that confidence as well, to give back those decision making, not just to voters, but also to the leaders in the party. Now, I know, for instance, in the case of PRS, when they sacked their members in 2018, they lost 3 parliamentary seats. And I know now that the party leaders have actually learned from their mistake, So I'm sure in politics in Malaysia, we will also adapt as well. So I think it's not all bad. We may have this law, and I'm sure the parties will also adapt accordingly. Thanks.
Thank you. YB Azalina, any last word from you?
No lah. But of course, my concern is, the voters may not want to come out for PRU 15 lah, if we're not going to address all these issues that's concerning them. Thank you.
Yes. Thank you, YB. And thank you to all the esteemed panelists here for your presence. Thank you very much.
Thank you. I think before we go to the next sessions, maybe I want to take a photo.
Yeah.
Or the photographer. Take a photo. YB Azalina, can you on your... Is YB Azalina still? Is she left already? Okay.